Good morning. I've called the case, so each of you will have 15 minutes to present your oral arguments. The appellant, of course, can reserve up to 5 minutes for rebuttal and keep the time on the clock on the TV there. Please set it here before we get started. And we've read the briefs and we're prepared to proceed if you want.
Great. Thank you. Good morning, Your Honors. May it please the Court. I'm Scott McKinley, here on behalf of the appellant, YRC Worldwide. I'd like to request 3 minutes for rebuttal.
Very good.
Thank you. We request that the trial court's decision in this case be reversed and remanded for 2 reasons. First, the trial court erred by admitting into evidence the opinions and diagnoses of non-testifying physicians because such diagnoses were impermissible hearsay on the ultimate issue and did not satisfy the height of 7-factor test for admission under the business records exception of Evidence Rule 8036. Second, the trial court erred by admitting into evidence documents and testimony referring to the underlying administrative activities because such references were irrelevant, misleading, confusing, and prejudicial. As to the first assignment of error, the 9th District case of Garrett v. Dentis. In that case, this court held that medical opinions and diagnoses from non-testifying physicians are not admissible even if contained in records falling under the business records hearsay exception of 8036 unless they satisfy the 7-factor test provided in height of each Schwendemann. This is obviously a workers' compensation case. The underlying claim, whether that's allowed or disallowed, is not in dispute. The jury was only asked to determine in this case whether the claim should be additionally allowed for the specific condition of post-concussion syndrome. Diagnoses from non-testifying physicians were introduced into evidence to support plaintiffs, the appellee's case in chief, and those diagnoses failed not 1 but actually 4 of the height of factors. The first factor I'd like to address is actually the 3rd height of factor. That states that the out-of-court test or diagnoses from the non-testifying physicians cannot be admitted into evidence under the business records hearsay exception if that diagnosis is based solely on subjective complaints of the patient. Now, in this case, again, the condition at issue is post-concussion syndrome, and that is diagnosed based on subjective complaints provided to the doctor from the patient. That's evident in the testimony from Mr. Somerick's own expert, Dr. Fry, a neuropsychologist. She testified that to diagnose this condition, she looks for subjective complaints of headaches, dizziness, concentration issues, and that will support her diagnosis. So all subjective complaints. She actually testified that it's nothing physical per se, and she said, quote, "You're sitting in an office across from me answering questions," unquote. Additionally, the diagnoses from the non-testifying physicians, specifically Drs. Gebel, Miller, and Fuscoda, they also based their opinion on whether Mr. Somerick has post-concussion syndrome based on Mr. Somerick's subjective complaints of headaches, dizziness, pressure in the forehead, and memory issues.
One of those doctors had treated this gentleman for 20-some years, I think.
Correct. Dr. Fuscoda is the family doctor, Mr. Somerick's family doctor. So, yes, he was a treating physician and had seen Mr. Somerick prior.
The 2 were neurologists, I believe.
Correct. Yes.
Both doctors examined this man.
Did the 2 neurologists examine?
All 3 of them?
Yes.
I would imagine had.
Yes, all 3 examined. Dr. Fuscoda, you're correct, Your Honor, had been treating Mr. Somerick for years. Dr. Gebel treated Mr. Somerick on 1 occasion, as did Dr. Miller, both neurologists.
And they had no objective findings of post-concussion syndrome?
No objective findings of post-concussion syndrome. They did conduct objective reviews, but those objective reviews did not contribute to a post-concussion syndrome diagnosis. If you look at their records, they opine that Mr. Somerick has post-concussion syndrome based on his subjective complaints of headaches, dizziness, etc. Their objective findings, if you look at them, in fact, Dr. Miller, for example, he does a 12-system objective review. And of all those systems, they're all normal. He also reviewed a diagnostic test, the brain MRI. So that's objective, obviously, but it was normal. So these were normal objective examination findings. Those were not used to justify a post-concussion syndrome diagnosis.
I thought they were used in the respect that they eliminated other things, so that
sure if that's necessarily the case. I believe Dr. Fry had mentioned that to have post-concussion syndrome, you would need a normal diagnostic test. And I think she was saying that that would then indicate that there was a more severe head injury beyond a concussion. And that wasn't the case here. The doctors, the neurologists, Drs. Miller and Gebel, made no mention that they were looking for a normal objective diagnostic test to justify the diagnosis of post-concussion syndrome.
Well, did anyone testify that, from your side, that you have objective tests that you can complete in order to determine whether somebody's suffering from post-concussive syndrome?
Yes, so Dr. Friedman will look at objective tests, and he differs from Dr. Fry. So he'll look for the subjective complaints. I think all of the doctors agree with that. He also will do the clinical exam and look for focal nerve deficits. That was done by the neurologists, Dr. Gebel and Miller, and their neurological examination findings were normal. Dr. Friedman will do that as well. He will also look at prior medical records, and he'll do a medication analysis to see if there's medications, and this was relevant in this case, medications which could be causing side effects that mimic that of post-concussion syndrome. So Dr. Friedman will look at these objective tests. I think what's important when analyzing this matter under the second hyperfactor is, are the non-testifying physicians applying an objective test? And it doesn't appear that they are. It looks like according to the records, their diagnosis of post-concussion syndrome is based simply on the subjective complaints.
Okay, and I guess that's what I was getting at. Maybe I probably didn't ask the question very artfully. So was there a difference of opinion about that, or was that everybody agreed that there had to be objective testing, or there had to be objective results, and you couldn't go on the basis of subjective?
There certainly wasn't a uniform agreement as to the process, and I think that brings us into the second hyperfactor. That states that in order for the diagnosis to come in, the diagnosis must be based on a well-known, objective, accepted testing practice and procedure that is not of such a technical nature so as to require cross-examination, and we don't have that here. None of the non-testifying doctors even provided what their scientific methodology was for diagnosing this condition, and we don't know that because they were never called to testify. Dr. Fry, a neuropsychologist, she relies upon the DSM-5, the Diagnostic and Statistical Manual of Psychiatry, to diagnose this condition. And remarkably, the DSM-5 actually doesn't recognize the exact condition of post-concussion syndrome, and Dr. Fry, up until trial in her treatment records, never diagnosed Mr. Somerick with post-concussion syndrome. Rather, she said he had a condition called mild neurocognitive disorder due to a traumatic brain injury. So there's confusion on what is the proper condition. She also stated that you diagnose post-concussion syndrome when someone has a concussion and 7 days later their symptoms are still lingering. So she has a 7-day benchmark. She's the only doctor in this case that mentions this 7-day benchmark. The non-testifying physicians, Gebel, Miller, and Muscoda, don't mention the 7-day benchmark, let alone rely upon it. Neither does YRC's expert, Dr. Friedman. And then, as you pointed out, Dr. Friedman has a different methodology for diagnosing the condition. All of this to say, I think the waters are muddy when it comes to how do you diagnose this condition, post-concussion syndrome. It's a unique condition in that, unlike a broken arm, where you can hold up a diagnostic x-ray, it's objective, you can look and see a fracture in the bone and make a pretty accurate diagnosis, there's a broken arm. We just don't have that with this case, with post-concussion syndrome.
Was it mentioned in the trial that this is like anything similar to what the football players suffer?
As far as like maybe CTE, that exact condition, I know both attorneys had discussed some of that during voir dire. I don't know if it actually specifically came up.
I was just wondering.
Yeah, I don't think that was a major
Because I think
point.
that's the first thing people think about, so that's why we probably did it during voir dire to try to.
Yeah, I think you're right, and CTE is another just kind of unique condition that people are still trying to get their hands on of exactly what that is. When it comes to these head injuries, I think that's the point. It's difficult to diagnose. They're based on subjective complaints. There is no hard, fast, uniform rule. And that's why cross-examination is necessary. When a physician is making this diagnosis on the ultimate issue, the party has to be allowed to test the validity of that opinion, test the qualifications of the doctor making that diagnosis, even test to the reasonable degree of medical certainty. How certain is this physician? And that leads me into the fourth and fifth height factors, which, again, we're also not satisfied. Those require that in order for the diagnosis to be admitted from the non-testifying physicians, the diagnosis must be made by a qualified individual, and that evidence must be competent and relevant. Well, it's relevant, but it wasn't competent because we don't know that these non-testifying physicians were qualified to make this expert diagnosis. There was no proper foundation laid for them. They were not qualified under Rule 702 by the court as experts in this field. And most importantly, they don't tell us, they don't declare to what degree of certainty they are making their diagnosis. So obviously an expert opinion being offered into evidence needs to be to a reasonable degree of medical probability, if not certainty. They are not making that declaration. So we don't know how certain they are, but yet it's being presented to the jury as if this is a scientifically valid diagnosis from a qualified individual to a reasonable degree of medical certainty. That's what the impression is for the jury, and that's just not the case.
So were there objections made?
There were objections, multiple objections throughout, and both in chambers and on the record, at least 3 or 4 times throughout the trial there were objections on this specific issue.
I'm going to pause you for a second. You're at 3:26 total time, so just so you're
Okay.
aware.
Thank you. I'll quickly just wrap up on the second assignment of error. There were admissions into the record of administrative proceedings. Basically, it was 3 C9s, which is an official request for treatment in the Industrial Commission. That was an error for 2 reasons. One, it was irrelevant. Courts upheld that. References to the administrative proceedings in a workers' comp appeal, which is de novo under 4123-512, are irrelevant and should not be relied upon, so those should have been excluded under 402. But also they were misleading in the sense that the treatment requested was subsequently approved. They were confusing because they turned the issue from one of just allowance of the condition into, does Mr. Somerick deserve treatment? So it turned this into a treatment issue. And then because of all that, it was highly prejudicial, and therefore this should have also been excluded under 403A because any probative value of these C9s was substantially outweighed by the unfair prejudice to the YRC.
You'll have 2 minutes and 30 seconds.
Great. Thank you, Your Honor.
May it please the court, my name is Mario Gaetanos, and I represent the injured worker, Mr. John Somerick. Just a little bit of knowledge of Mr. Somerick. He's a 30-year employee of YRC. He's a freight handler. He's had 2 injuries. One was a shoulder during this 30-year period, and one was this severe trauma to the head. He's not a malingerer. Now, if you read Dr. Friedman's report, and when he testified, he's basically telling the jury he's a malingerer. He's faking his symptoms. But keep in mind, this claim's been allowed for concussion. So the symptoms that he was suffering from, the dizziness, the anxiety, the loss of memory, short-term memory, the lack of concentration, those were allowed in this claim. So the issue becomes, did it exceed more than 7 days? Based on the testimony of Dr. Fry. Dr. Fry, from the Cleveland Clinic, very qualified neuropsychologist, very good reputation. She diagnosed the post-concussive syndrome, as did other doctors. Even their other expert witness who did not testify, Dr. Soderstrom, said that he's had these post-concussive symptoms for the last 2 years. And he examined him 2 years after this.
But was there objective testing by these other doctors?
There was the testing. What opposing counsel is referring to is subjective. Subjective is, what does the injured worker say to the doctor? The other factors are clinical evaluations. They're looking at the person, they're evaluating the person. How do they react? How do they act? It's not just merely subjective complaints. Every single doctor evaluating this person, Dr. Goebel even indicates in his report that, and this is Claims Exhibit 4, on the 3rd page, on neurological examination, not quoting, he does have mildly diminished attention span and concentration, his mood is mildly anxious, and he goes on with other issues, photophobia, light sensitivity, those type of things. So that's just merely what Mr. Somerick is telling the doctors. They're doing clinical evaluations. Is there one test that can determine whether you have post-concussion syndrome? No. And just the basic definition of post-concussion syndrome, it's a multi-systemic, if you will, type of condition that needs to be diagnosed by an expert.
Is there testing that would rule out post-concussion syndrome?
Not that I'm aware of. Now,
So
the MRI,
merely because it doesn't show on it?
right. The MRI finding, which was normal, you have to have a normal finding in order to have post-concussion concussive syndrome. That's the testimony of Dr. Fry. If you had some type of condition, bleeding in the head, then you have a different type of condition. And you could have, and Dr. Fry had diagnosed him as having a mild traumatic brain injury, because all concussions are a form of traumatic brain injury. And she diagnosed it as a mild. Now, opposing counsel mentioned something about the DSM-4 and DSM-5. There are 2 diagnostic manuals. Dr. Fry was using DSM-5 when she did the initial report, and then based on the DSM-4, she said that this is basically post-concussive syndrome. It's the same type of condition, very similar, so it's just a word issue from using either DSM-4 or DSM-5. But if you look at the reports from Dr. Fry, who did a 2-day testing of my client, spent 2 days, part of Claims Exhibit 2, she went through all kinds of tests with Mr. Somerick in arriving to the diagnosis of the post-concussive syndrome condition. I think the medical evidence is overwhelming in this case, Your Honors. Again, Dr. Soderstrom recognized that he has post-concussive syndrome symptoms. Dr. Freeman, I don't think was very well liked by the jury. That's my personal opinion, because he's suggesting that he's a malingerer or trying to place blame that because he was diagnosed with attention deficit disorder when he was a kid, that has some effect or impact on his condition today, or other factors as well.
Did Gebel, Miller, Placoto, and I don't want to mispronounce his name. Soderstrom, do they need this? Was it required for them to state their opinions within a reasonable degree of medical certainty or diagnosis?
Well, Dr. Fry did, and she was very clear with it. But the records that opposing counsel is referring to, those are treatment records. They're kept in the regular course of, in a systematic way, of treating Mr. Somerick. They were not being offered as expert witnesses, if you will, by way of its testimony within a reasonable degree of medical certainty. They did evaluations. They all did evaluations. They came to the conclusion he was suffering from these symptoms. And then, obviously, Dr. Fry felt that those treatment records, which she did review, also assisted her in her diagnosis, because she even refers to her report that she did review some of the medical records, including Dr. Placoto. Dr. Placoto, I think it's either more than 20 years, possibly, or maybe you're right, it was 20 years. Mr. Somerick was working without any type of problems just prior to this incident. He was not suffering from any type of concussion symptoms or post-concussion symptoms of any kind. He was working without any restrictions for a long and extended period of time. After this incident happened, he was in the hospital for 4 days. And the facts, and I don't know how much time I have left, I'm not keeping track of it, Your Honor, but...
It's up on the clock. You have 8 minutes and 40 seconds.
Okay. The way this happened and how he was treated was horrendous. He had this deck bar, fall on his unprotected head. No EMS was called. He was basically told to get a taxi. They called for a taxi. That was kind enough, but he had to walk an extended period of time, because at this terminal has 200 doors. He walked his way to a bench near the street, passed out on the bench, bleeding. The taxi cab finally picked him up. He passed out in the back seat of the taxi cab. He remembers waking up, and this is all through the testimony. He recalls waking up. The cab driver was yelling at him, "You got blood in my car." He gets out, goes to Concord, or Concentra Medical Facility, waits 3.5 hours there, no treatment for 3.5 hours. As soon as the doctor gets there, the doctor basically, first look at him, says, "Go to the hospital, EMS." They called EMS, he's transferred to Akron General Hospital, spends 4 nights in Akron General Hospital due to this head trauma. The medical evidence, I think, is overwhelming. I think we met the height of test relative to
Well,
the treatment records.
You're saying the clinical evaluations are the objective testing here. The height factor requires that the diagnosis be a result of a well-known and accepted objective testing and examining procedures that are not so technical as to require cross-examination. So you're arguing that clinical evaluations are a well-known and accepted objective testing?
Absolutely. I mean, you've got Dr. Gebel, if I'm pronouncing right, he's a neurologist. You have Dr. Hugh Miller, he's a neurologist. You have Dr. Fry, a neuropsychologist, who does all the various types of
Would it be
testing.
different if they were not neurologists? Your answer probably would be different.
Well, no, I think that because they're a neurologist and they did the clinical evaluation, the examination of the client, I think I think they satisfy the height of test. So based on this, we would request that the appeal be denied.
Well, what's your argument as to the evidence of the administrative proceedings coming up?
I forgot to mention it. Those C9s that were attached to the records are part of the normal process. They do not reference what are allowed or denied conditions. They're basically requests for treatment. That's all it is. There's no reference to what's allowed or denied in the claim whatsoever. It's not prejudicial to the jury at all. In fact, the defendant, YRC, brought in as an exhibit an IC record of proceedings, which was highly inappropriate. And that was offered as, I believe, as Defense Exhibit V, I believe it is. That wasn't our exhibit. That was YRC's exhibit. But there's nothing prejudicial with respect to the C9s. There were 2 or 3 C9s, just requesting treatment. That's all it was.
How are they relevant, though?
Well, it's relevant because it goes to the issue that Mr. Somerick needed further testing. And that's all really it was requesting. He needs further neurological testing. And the one C9 that I recall from Dr. Ploscota was he made the referral to Dr. Fry. He needs to be seen by Dr. Fry. And eventually he did. That's all it refers to. It doesn't say anything about the claims allowed for post-concussion syndrome. And I think that's what is significant. If that was the case, I can see where that would be prejudicial. With respect to the medical records also, that YRC is objecting to, anything regarding causal relationship was redacted. We whited everything out. We went through all the records, and anything regarding causal relationship, because that's the ultimate issue here. Does he have the right to participate, Mr. Somerick, in the Workers' Compensation Fund for post-concussion syndrome? That's the ultimate issue. And that ultimate issue was always redacted if it was in any of the medical records that YRC is objecting to.
So that's interesting. Did both parties go, was it a process where both parties sat down and agreed?
Correct, we went through. Thank you.
Okay, thank you. You've got 2 minutes and 29 seconds, counsel, for your rebuttal.
Thank you, Your Honor. I'll be very quick. I disagree. The causal may have been redacted, but the ultimate issue is the diagnosis of post-concussion syndrome. That's what this whole case was about, and that was allowed to come in. That's the whole reason for the appeal. Quickly, as for the objective findings from these neurologists, again, if you look at them, Dr. Miller, he notes of his 12-system review, speech and language, normal, cranial nerves, normal, motor strength, normal, appearance, normal, cardiovascular, normal, review of the MRI, normal. This is not supporting a post-concussion syndrome. It was only based on subjective complaints. Same with Ploscota and Gebel. And Gebel, interestingly enough, he defers on his actual diagnosis of post-concussion syndrome. In the beginning of his report, he opines that Mr. Somerick has typical post-concussion syndrome, but if you look at his final diagnosis, he doesn't put in post-concussion syndrome. He puts in concussion and post-traumatic headache, and then he punts on that condition and refers to Dr. Fry, the neuropsychologist, for further testing on cognitive development. So I think if he was called to testify, I don't know if he would even state that he's, to a reasonable degree of medical certainty, believes Mr. Somerick has post-concussion syndrome. I don't know if he would state that Mr. Somerick, that he's qualified to make that decision, given that he's referring Mr. Somerick off to a different specialty. And he, because of that, probably would not be able to state that he's got a scientifically valid method. Again, that's the whole point of this appeal, is this is the reason why you need to be able to cross-examine experts. And finally, just very quickly on the diagnosis between different conditions between Dr. Fry, that wasn't just a matter of wordsmithing where she's calling it neurocognitive disorder versus post-concussion. That's not true. If you look at the records, when she's treating Mr. Somerick, she notes the claim is allowed for post-concussion syndrome. After making that, she files a formal motion in the Industrial Commission requesting that the claim be additionally allowed, in addition to post-concussion syndrome, for mild neurocognitive disorder due to a traumatic brain injury. So she's certainly not believing they're the same. Why would she file that motion? Finally, just the record of proceedings as to the second assignment of error. We did submit a record of proceedings, and the only reason we did that was because our objection for the C9s coming in was overruled, and therefore we admitted that to show, hey, this treatment that is being purported to show denied treatment, it was approved. This was approved treatment, and that was the reason we submitted that evidence. So, see that I'm out of my time. Thank you.
Thank you both for coming in and presenting the court with these interesting arguments. The court will take the matter under advisement, issue a decision in due course. The clerk of courts will certainly leave you a copy of the court's decision on the day it's released, and also you should know that the court's opinions are posted on the Supreme Court of Ohio's website. Now,